Hello friends, welcome to the second lesson of week 2 where we are talking about the comparison of judicial process and various other area processes with mediation. So we've already dealt with judicial process versus mediation, and today we'll be dealing about arbitration versus mediation. So as said by Mr. Richard Cobden, and I quote, "At all events, arbitration is more rational, just, and humane than resort to sword." So, when we talk about arbitration, first we need to understand the meaning of arbitration. What is arbitration? Arbitration comprises of few important things which include settlement of a dispute. So arbitration is one of the modes to settle your dispute by a third party. This would be an arbitrator in this case, and this arbitrator would be undertaking the process of adjudication, and he will be delivering the verdict in the form of an award. So the result of arbitration is an arbitral award, and then which is enforceable in the court of law. So this arbitration award is enforceable in the court of law. So as we read along, arbitration means the settlement of a dispute by a third party arbitrator, usually chosen by the disputants, who undertakes the process of adjudication and delivers the verdict in the form of an award which is enforceable in the court of law. Next is, where is arbitration governed? So arbitration is governed by the Arbitration and Conciliation Act of 1996, which extends to the whole of India. Now, in this Arbitration and Conciliation Act, this provides for the jurisdiction of the tribunal, the procedure, the removal of arbitrator, the international arbitrator, enforcement of foreign awards, and various other provisions. So it's a very extensive act which provides for a lot of things. Now we'll be talking about the features of arbitration. So the first amongst them is formal or informal, whether arbitration proceedings are formal or informal. So when we talk about judicial process, it's a very formal process. But arbitration, as compared to a judicial process, is less formal. Although in arbitration also we have the exchange of pleadings and documents, and examination of witnesses also takes place here, but the strict rules of arbitration do not apply. The strict rules of law which are there, which are followed in the judicial process, they are not followed as strictly in case of arbitration. Now next is arbitrator. Who is an arbitrator? So it is open to have more than one arbitrator, in which event what happens is each of the party appoints an arbitrator, and the two arbitrators together they select a presiding arbitrator. So, and in case the parties fail to appoint an arbitrator, then the court has to take control over the appointment of an arbitrator. So it is open to both the parties to appoint an arbitrator each, but those two arbitrators will collectively decide for one presiding arbitrator, and if there is no settlement, then the court will decide for the arbitrator. Next is challenge of the award. So the award which is arrived at towards the end of arbitration proceedings, that can be challenged in the court, which for which the grounds are stated in the Arbitration and Conciliation Act of 1996 itself. Now, arbitration is one of the most recognized alternate dispute resolution mechanism. But what is the need? Why is arbitration becoming a stumbling block? What is the need of having other processes than arbitration? So, one of the reasons is that it has failed to deliver the promise which it had earlier stated, that is, erasing the court's backlogs. Arbitration was believed to erase court's backlog in a very huge manner, but as we see nowadays, even arbitration is failing to deliver its promise. Next is the proceedings of arbitration are becoming as technical and as procedural as the proceedings that we follow in the court of law. Next is fees of the arbitrator. So the arbitrator is given a fees, and now in the present times the fees of the arbitrator has skyrocketed. They are demanding high amount of fees. Next is delay in giving awards. So the arbitration proceeding is stretching out to be so long that there is a huge delay in giving the award to the parties. Next is there are two types of arbitration proceedings. One is institutional arbitration, one is ad hoc arbitration. So in institutional arbitration, everything is prefixed, like the time span in which the arbitration has to finish, the fees of the arbitrator. These pitfalls that we discussed about arbitration, they are less likely to happen in institutional arbitration since the things are prefixed. But nowadays, the trend of ad hoc arbitration, that is an independent arbitration without the involvement of an arbitral institution. So, the instances of ad hoc arbitration are rising and the instances of institutional arbitration have reduced. So, ad hoc arbitration is becoming more in fashion these days. So, again, the burden which arbitration carries along is going ahead. Next is restriction under the 1996 Act. So, under the 1996 Act, as we talked, that there are the grounds of appeal for an arbitral award, so that on those grounds the award can be challenged. But these grounds are very limited. So again, the parties tend to give into what has been decided by the arbitrator. But what if there are instances where the arbitrator is himself in a mistake of fact or a mistake of law, or whether we can trust the integrity of an arbitrator? That also creates a doubt. So there, another restriction of arbitration is coming into place. Next is suitability. So arbitration is suited to cases where the dispute is of highly technical nature and where mediation, like where a consensual mode of dispute resolution like mediation cannot be used. So in those cases arbitration is more fit. Next is approach. So the approach of the arbitrators these days is becoming more like what is the approach of courts. So a full legal technical procedure is followed these days by arbitrators as opposed to what the arbitrator is encouraged to follow, that is mediation and conciliation. These techniques should be followed, but nowadays again the approach is becoming more oriented towards following complex court procedures. Now, when we talk about an arbitration agreement, what are the essentials of an arbitration agreement? So, the first essential is form of arbitration. So, the arbitration can be in the form of a clause in an entire agreement or an agreement in itself. So there can be a separate clause which talks about arbitration, that if there is a dispute it would be referred to arbitration, or there will be a separate agreement altogether which says that in case of any dispute it has to be referred to arbitration. Next is must be in writing. So when is an arbitration agreement believed to be in writing? So when it has been signed by both the parties, when there is an exchange of a form of communication like letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement. And next is exchange of statement of claim and defense, in which existence of an agreement is alleged by one party and not denied by the opposite party. Next is valid contract. So the arbitration agreement should the agreement of the arbitration should be a part of the valid contract. So all the essentials of a valid contract which have been provided under section 10 of the Indian Contract Act of 1872 have to be followed. Next is intention. So the intention of the parties has to be to refer the dispute to an arbitration. So in case any dispute arises, so that dispute should be referred to arbitration. That should be the intent of the parties. Next is dispute. So to refer to arbitration, in the first place there has to be a dispute. So there has to be a dispute, present or future, between the parties to the arbitration. So before you also have a chart which tells about all the vital essentials of an arbitration agreement. Now next is which matters can be referred to arbitration. So as you can see before yourself, there's this matter of calculating damages in the event of breach of contract. Then there can be an issue of question of validity of marriage. Then there can be an issue of maintenance payable to the wife. Then there can be an issue of time barred claims. And there can be an issue of commercial nature. So all these disputes can be referred to arbitration. Now next is which are the matters which cannot be referred to arbitration. So these matters include matrimonial matters such as divorce, restitution of conjugal rights, etc., insolvency matters, matters relating to guardianship of minors, industrial disputes, rent disputes, criminal matters, and winding up petition. So these are some examples which cannot be referred to arbitration, where arbitration would not be a fit way of resolving the dispute. Now next we talk about arbitral tribunal. What is an arbitral tribunal? So as per section 2(1)(d) of the Arbitration and Conciliation Act of 1996, it means that it can be a sole arbitrator or a panel of arbitrators. So one thing which we should note is that there should be an odd number of arbitrators present in the tribunal so that they can reach to a fair decision. Because if there is evenness, then how will the arbitration award be decided? So it's best to have an odd number of arbitrators. But there has been a case of MMTC Limited versus Satellite Industries India Limited, in which the court said that even if there are even number of arbitrators, the arbitration agreement cannot be termed as invalid. So in MMTC Limited versus Satellite Industries India Limited, it said that section 10 provides that the parties can freely determine the number of arbitrators, but such arbitrators should be odd in number. Now this is important to ensure that there would be no chances of a tie in the decision making. So, but the court said that however, if there are even number of arbitrators, the arbitration agreement cannot be termed as invalid. Now next we come to the point of differences between arbitration and mediation. So the first point here is the role of the neutral party. So the role of the neutral party in case of arbitration, that is an arbitrator, would be that of a decision maker. But in mediation, the role of the mediator, that who is the third neutral party, is of a guide or a facilitator. Next is the nature of process. So the nature of process in arbitration is adversarial, whereas in mediation, the process is consensual. Next, we talk about the decision maker. Who is the decision maker in case of arbitration? It's the arbitrator. Whereas in mediation, the decision maker is the parties. The parties are in control of the decision making process. Next is legal rules of procedure. So the legal rules of procedure in case of arbitration apply, but they do not apply as formally as they apply in the court of law. But in case of mediation, the legal rules of procedure do not apply. Next is lawyer's role. So the lawyer's role in case of arbitration is to display advocacy, whereas in mediation, it is to be an advisor or a participant. Next is focus. So the focus in case of arbitration proceedings is on the past act and establishing the liability, whereas in case of mediation, the focus is on the present and future and finding viable solutions. Now, when we talk about time, so in case of arbitration, there is some delay, and when the award is challenged, then the chances of delay is even more increased. But when we talk about mediation, mediation is a comparatively quick process. Then is confidentiality. So, the proceedings of arbitration are confidential unless they are challenged in the court. But mediation is all in all a very confidential affair. When we talk about the result of arbitration, so the result of arbitration is an award, arbitration award, and in case of mediation, the result of the mediation proceedings is an agreement between the parties, a mediation settlement, or a failure to agree. Also, when we talk about the result, there can be a challenge of the arbitration award, but the grounds of challenge, as we discussed earlier, have as been stated in the 1996 Act, is very limited. Now, next is control. So, when we talk about arbitration, there's a greater level of control with the arbitrator, and there is some control over the procedure with the parties. Whereas in mediation, the parties are totally in control of the decision making, whereas the mediator is in control of the process of mediation. When we talk about arbitration, arbitration is potentially expensive, whereas mediation is believed to be reasonable. As we discussed earlier, in case of ad hoc arbitration, where the charges, the cost of arbitration is humongous. Then when we talk about satisfaction, then in arbitration, the degree of satisfaction is low, whereas in mediation, the degree of satisfaction is very high. The choice of neutral party in case of arbitration is neutral. So each party can appoint an arbitrator, and that party will be deciding a presiding arbitrator. But in case of mediation, there is total choice of the neutral person which the parties want to be a mediator. Now, how is decision enforced? So, in arbitration, the decision, that is the arbitration award, can be enforced through a legal process. Whereas in mediation, it can be enforced as an arbitral award if it is required. When we talk about termination, when we talk about arbitration, the termination happens after arriving at an arbitration award. Whereas in mediation, the termination is on the successful completion or termination by either the party or the arbitrator, by either the party or the mediator. Then when we talk about creative solutions, so when we talk about arbitration, the probability of arriving at a creative solution is very less likely, but in mediation it is very much possible and desirable at the same time, because it depends on the facts and circumstances of a particular situation, the needs of the parties. Everything is evaluated by the mediator. Next, when we talk about the flexibility of procedure, so in arbitration, the procedure is quite it can be made flexible. The flexibility is possible, but in mediation, the process is highly flexible, because, as I earlier said, that as per the needs of the parties, the facts and circumstances of the case, everything is evaluated by the mediator, and the procedure can be made very flexible as per the needs. A joint session or a private session can be held that way. Next is effect on relationships. So arbitration is not very helpful when we talk about the relationship aspect between the parties. But when we talk about mediation, so the effect on relationships is most probably believed to be positive, and it is very less likely to harm the relationship between the parties, because the main aim of mediation is to not hamper the relationship between the parties, to keep it intact and arrive at a win-win situation for both the parties. Next is regulation of practitioners. So in case of arbitration, only in institutional arbitration we can see that there is a regulation of practitioners. When we talk about mediation, only at present there is the court annexed mediation. Only in those cases we can see regulation of practitioners. Next is interim relief or urgent relief. So when we talk about arbitration, it is possible to have an interim relief, but there can be some chances of delay. However, in mediation, urgent or interim relief is not possible, because again, effective communication has to be there. The parties need to communicate to each other effectively. The mediator has to take control of the process. He has to ensure that both the parties communicate and display their needs and resolve the dispute. So to resolve the dispute amicably, it needs time, it needs effort. So an urgent or interim relief is not possible in case of mediation. Next is deciding or interpreting questions of law. So determination is inter partes in case of arbitration, whereas in mediation the decision of the interpretation of question of law does not happen. When we talk about the cost of parties, in case of arbitration, it can award cost to the successful parties, but in case of arbitration, in case of mediation, the cost is usually equally borne by both the parties. The next, when we talk about creating precedent, it is limited to the parties in case of arbitration, whereas chances of creation of precedent in mediation is nil, because each case is new, the facts of each case is new, the perception of parties is new, and accordingly the terms of settlement is new. Now, let us talk about an illustration to understand better how arbitration and mediation are different, and how mediation fits best in a situation, and how arbitration would be used to decide the same situation. So, in this illustration, there's a family, and and there is a father, two sons, and mother. So, the father has died very recently, and the mother had already died earlier. So the only surviving heirs, the legal heirs of the father, are the two sons. So now the father has made clear in his will that the entire property would be divided equally between the two of them, that is in 50-50 proportion. When he talked in his will, he has talked about his family home and various other properties that he has. But when it came to the family portrait, so the family portrait was painted by a very renowned Indian painter. So for that, the father in his will, he has mentioned that this family portrait will go to my favorite son. So in that portrait, there is the parents, the grandparents, and it is a very cherished family possession. But there is a huge ambiguity as to who is the favorite child, because that has not been stated. The will only states that the painting will go to the favorite child of the father. So the two brothers cannot agree to who is the favorite child. Now, we'll see that how the same dispute is resolved by means of arbitration and how it will be resolved by mediation. So first, when we talk about arbitration, the framing of issue will be taken care of by the arbitrator. So the issue here will be which child fits in the definition of favorite child. Next would be that each party would be presenting their reasons as to why do they believe that they are the favorite child of the father. Next is that the arbitrator would evaluate the evidence and decide on the basis of the evidence as to who fits in the definition of favorite child. Next would be that in the case of arbitration, no compromise is permitted. So arbitrator would decide who is wrong and who is right on the basis of two important factors. What is the meaning of the favorite child? And second is appraisal and comparison of evidences presented by each of the parties as to why they were the favorite child. Now when we evaluate the same situation as mediation, in the case of mediation, so the mediator will try to facilitate a negotiation of the same issue. The issue will be the same, who is the favorite child, but the mediator will try to facilitate a negotiation here. Now, the parties will try to work out with a possible solution between themselves rather than relinquishing all the control to a third party, that is the mediator. Now, here the parties will try to work out a solution between themselves as to they'll decide amongst themselves, and rather than relinquishing control over the resolution of dispute to an arbitrator or to any neutral party. They'll not leave the decision up to an arbitrator as in case of arbitration, but they'll try to work out a solution between themselves. Now, the parties are free to choose creative compromises. So there is no necessity of having a wrong and a right in a mediation proceedings. And there need not be only one winner. The parties can work out a solution where both the parties are in a winning situation. So the mediator here has to demonstrate some skills. One would be identifying the needs. So the needs of both the parties would be identified. Second would be to create creative options. So creative options or solutions can be suggested by the mediator here. Next is controlling the process. Very important is that in case of mediation, the mediator is in control of the process. He has to control the process in order to see that the relationship between the parties does not get hampered. But the decision-making process is in control of the parties. Next is restoring the relationship. So the mediator will try to restore the relationship between both the brothers so that the dispute can be resolved as a win-win situation for both the parties, and an amicable resolution of dispute can be furthered. This is all I would like to explain. Thank you, and I hope that you enjoyed the session.